SJC-12053, Timothy Deal, V., Commissioner of the Department of Correction.
Good morning, Ms. Caban.
Good morning, Your Honors. Barbara Cabin on behalf of the petitioners. With me today is Attorney Ben Keene and Attorney Jim Lucille. In response to this Court's and the Supreme Court's recognition of the distinctive attributes of youth and their heightened capacity for positive change and rehabilitation, the 2014 Massachusetts legislature chose to limit DOC's long-standing, unfettered placement discretion when a lifer was a juvenile at the time of the crime.
Let me ask you a question. Somebody has a lifer has a 15-year period within which to be eligible for parole. The objective documentation says that as of year 2, this person qualifies for minimal restraint circumstances. Is that really what you're advocating?
No. The way the DOC objective classification system works, there's the actual calculation of a score, and the score itself generates a security level. 6 points or less qualifies you for minimum security. But then there's the application of the mandatory restrictions and then the discretionary restrictions. One of the mandatory restrictions, Code A, actually says you're not eligible for minimum security placement until you're within 5 years of your parole eligibility date. That, we're not contesting that that is a reasonable restriction.
Okay. Can I just ask you, something I read, and I think it was in the department's brief, but suggesting that in this case, you are limiting it to 18 months, is that right?
No, that is not actually correct. I think that arose out of the fact that when we've actually filed the original papers, Timmy Deal was within 18 months, and I was saying it's an appropriate time for him to be able to move to minimum. We weren't saying that. In fact, the system that they have in place, the DOC objective classification system, is based on a whole range of reliable and valid measures, and they've developed a system that makes sense. We have no problem with the system in general. What we have a problem with is the fact that the legislature in 2014 limited DOC's discretion, and now, pursuant to what they call DOC practice, they will not honor the actual rules of the legislation. They will not move a juvenile homicide offender to minimum security unless and until they receive a positive parole vote.
How does that violate the statute?
Well,
Putting the condition of having received a positive parole vote. How does that violate the statute?
the statute actually says if the youthful offender qualifies for placement in a minimum security facility based on objective measures determined by the department, that's the classification system, the placement shall not be categorically barred based on a life sentence.
No, so it's barred based on the fact that they haven't received a parole authorization.
No, it's based on the fact that they have a life sentence. Parole is basically after the fact. What the department has done is interpret. In fact, they say we haven't imposed a categorical bar because, in fact, what we do is we let them to go to minimum after the positive parole decision. But there is no place in the statutory scheme, in the regulations, or in the DOC classification manual that mentions the parole hearing as the predicate for minimum.
So you think, well, I know there's no mention of it at all, so why can't the department use it?
Because the legislature has chosen to limit their discretion with this language very specifically for this particular cohort.
So you mean there can be no restrictions then?
No, I'm not saying that.
Because of the life sentence?
I'm saying that the mandatory restrictions that were memorialized in codes E and F are no longer applicable.
Right. E is gone, and F has been adjusted.
E was for the first degrees, F was for the second degrees,
Right.
and they're gone. And they actually, and DOC, the acting commissioner at the time of the change in the law, actually recognized that.
I don't think F is gone. I think it's just been modified as to how it's
F,
applied.
basically, they inserted excluding juvenile homicide offenders.
So if the assistant commissioner or deputy, I can't remember the title, is it Michi? How do you say it?
Michi.
Michi.
Respondent Michi, yes.
Is if her view is, well, I don't know, minimum security has no perimeter boundaries, and I'm looking at these statistics about where escapes are happening, and I know that this person who was convicted of a first-degree murder is eligible for parole. I don't have any clue whether he is going to get it. And so there's a real risk about putting somebody in those circumstances in minimum security, given the realities of our system, she says. And so it's not because he's got a life sentence, it's because I don't know if he's really going to, it's unlike a set sentence when it's going to happen. I don't know whether he's going to get parole, and therefore I am taking a very large risk in putting this person there who doesn't know whether he's actually going to get parole or not, and so has a real reason to escape.
The fact of the matter is that after they, I have multiple answers to that, multiple responses. The risk of escape is no different before or after the parole decision, because the fact of the matter is when they're going to minimum, they're there for a year or more in some cases.
It is different. It is different, though.
Well, let me finish my thought, and then we can talk
I'm
about
sorry.
it a little
I'm
bit.
sorry.
The fact is that they have this year in minimum, and if they screw up in any way, they immediately go back to medium. So there is the same vulnerability in many instances. The fact of the matter is that what they're doing in minimum is if they're successful in minimum, they're increasing the likelihood of a positive parole decision because they're actually having an opportunity to demonstrate maturity. They're functioning in a less structured environment, so they're basically given an opportunity to show that, in fact, they can handle less structure, they don't get in trouble. They are supervised. It's not that it's different from pre-release. It's not that they're going out to the communities, they have no boundaries. They are supervised, but they have an opportunity, as the DOC 2013 report actually enumerates, minimum security prepares an individual for pre-release, for release to the community, but also provides opportunities for more autonomous behavior and for basically beginning to develop some of the reentry skills you'll need. These are guys who've been incarcerated for 15 or more years. They need that transition. And the fact is that if you look at what's happening here, is that the statute, the legislature certainly knew about the fact that DOC had this policy that no one goes to minimum prior to a positive parole vote. And they specifically chose to address it in this 2014 amendment.
Well, they didn't specifically choose to address it. They said not categorically because of the life sentence.
Correct.
All right, so this isn't categorically because of the life sentence. It's because they have not received a positive parole eligibility vote.
Well,
But-
it's a proxy for life sentence. Would you say that that's the case?
Certainly. I mean,
They can't categorically, so what they say is you haven't qualified or you haven't gotten a positive vote for parole, so we can take that.
Yes, Your Honor, I would agree with that. That it's basically that. So let's look at what happens here for a second. We have this new statute, and based on this new statute, we would argue that in fact it is that the categorical bar based on a life sentence means the nature of the crime. Okay.
It applies to people, I mean, that particular sentence seems, because it uses youthful offender, applies to everybody who's been given a life sentence, whether it's for rape or, I mean, it's not just for murder, right? You agree with that?
Yes.
Notwithstanding the caption?
Well, except that if you look at where it was in chapter, in
I know that, but it
189,
just
it's
was
first degree.
surprising that the legislature chose to use youthful offender as defined in section 53, so it seemed to me to be broadening it.
Well, and I think that if you look, I think that it has been interpreted by the DOC to be broader, in fact. And if you look at where they placed this, they placed this in chapter 119, which is, the whole chapter based on the care and protection of children. And I think the legislative thought process, and we always would hope that they'd be a little clearer in their language. It frequently doesn't happen. But the intent was a remedial and protective intent, that they understood what the DOC past policy had been since 2006. They wanted to correct that.
The past policy was someone serving a life sentence could not be placed in minimum at all.
That's right. Well,
That was changed.
That was right, for first degree.
That was changed, right?
It hasn't been changed for adults. It was only changed for
For
this.
juveniles.
Yes, for juveniles, absolutely, yes.
Do we have any legislative history? I mean, this came in the same act that determined that there's a certain minimum amount of time for a juvenile to be released. Am I correct?
Correct.
So in fashioning, and I gather there was some debate as to what the length of time should be before a juvenile who has been convicted of first-degree murder could be released.
Yes, and the way it was written, it ranges anywhere from 20 to 30 years now for parole
But
eligibility.
does this reflect that the legislature understood the practice of parole, which is that it would not be releasing anyone to the street until they had gone through minimum security?
I have no legislative history that actually addresses that issue, Your Honor, so I can't actually answer what the legislature understood.
When you say that, do you mean you've looked and it doesn't exist, or that wasn't part of, I mean, it may exist? I'm not trying to put you on the spot. I'm just trying to figure out if you've actually looked and there's nothing there on that point.
Of what I was able to find, and my understanding from speaking to people, was that this legislative change went in rather quickly, and there wasn't a lot of discussion.
Okay.
But I think it was really, the fundamental issue was that there was an awareness that when juveniles were convicted of first-degree murder and they were incarcerated, they were frequently at the bottom of the list for treatments, for programming, because they were never getting out. And then
That's
there was,
changed. Sentence 1 has changed that. We're now
that's
talking
right.
sentence 2.
And then in sentence 2, they addressed the issue of this categorical bar. Now, when you think about what Respondent Michi says in paragraph 61 of her affidavit, she actually talks about the fact that, this is what she thinks is the best policy. And it's almost a statement of, yeah, we know what the law is, but this is what we think is the best policy. And that's what's part of the problem, because if you look at what happens, is that's the policy statement, unless and until they receive a positive parole vote, no one's going to minimum. But then how they actualize it, they enforce the categorical bar, it's through the use of these discretionary overrides, codes R and S, and it's a pretext for the policy that she has. And when you look at DOC regs, they're very specific. They say that, in fact, discretionary overrides are only to be used in 5 to 15% of the cases. DOC does not dispute that they're categorically imposing this bar on 100% of the juvenile homicide offenders who qualify for minimum security.
Could I ask you, if one of the things I inferred, and maybe incorrectly, from that affidavit was that there are relatively few beds in minimum. I mean, I appreciate that there's a report saying you should have a whole lot more, but here's my point. What if the department's position was, yes, we understand all that, but, here are people that we know they're going to be out. And so we are going to fill the available beds with them rather than, we have to make a choice. It's triage here, and we're going that way rather than with these juveniles. Would that be okay?
Who we do know nothing about whether they will be released now, in the future, or ever.
Couple of things. First of all, in their reply brief, in fact, the DOC now has taken the position that, it's not an issue of enough beds. They backed off a little bit on that. But in terms of who has the discretion and everything else, when they impose these discretionary overrides, they're supposed to provide a reason for it. I would imagine that in some circumstances, they could basically say, X and Y, we had one bed, and here are the two people, and in this case, because of this, and I think they could make a rational argument. It's not the case, though, that they don't
You
have
have to make case, but you're saying it needs to be case specific.
That's what the whole purpose of the discretionary overrides is, for an individualized determination of the appropriateness of this minimum security placement for this particular person. The way the DOC...
So the nature of the crime can be considered, right?
I'm saying that in some circumstances, sure, it could be.
Yeah, such as a murder.
Not
I
as a
know.
category.
It would have to go, yeah, it would have to go beyond the mere fact that it's a murder.
Why?
Because the whole cohort is there because of murder. So that basically becomes the blanket application. Once again, there should be some specifics about the fact of, who this individual is, what happened at the time of the crime maybe, or what happened subsequently in terms of his behavior in the facility. It needs more than just nature of the crime. Because again, that immediately takes us back to the pretextual use of the discretionary override.
All of these folks are serving life sentences, right?
Correct.
Some of them, you can get a life sentence for something that's not a murder.
You could.
Yeah.
But these three individuals basically are in for murder 1 or 2.
Right. Okay. So let me ask you this. So your position is we're not contesting, what is it, Code A, which says unless you're within 5 years of your eligibility date, you can't get in. You're saying somehow that's okay, right? That doesn't violate the statute. So you're saying, but anything within 5, they have a right to get in? Does the statute create a right to get into minimum security if you're within 5 years and you're sentenced to life? If you're in 5 years of some parole eligibility date, you're sentenced to life?
We're saying that if you're a juvenile homicide offender based on the statutory language and you qualify on the objective score,
Which is a fairly interesting but worthless score, it seems to me. It's a little bizarre. Have you committed any crimes in the last 4 years? I've actually been in prison for the last 15. Okay. Check.
Well, in fact-
Have you escaped? No. Check.
because what's happened, I think that's based on reliable and valid data that in fact shows that there's desistance over time. Yeah, and in fact, we do know that many of the prisoners do actually get charged if they attack a guard or other things can happen. So there are charges that arise in prison. Escapes, yeah, I agree, that's a little more bizarre. But in fact, that particular scale is used at the time of the initial placement and then annually thereafter. So there are reasons for the way they worded it. They
So
put
your
together.
answer is five. As soon as they're within 5 years, they have a right. As long as they've been classified through this objective criteria, they essentially have a right to be placed in minimum.
Aren't you, I thought you were saying, even so, it needs to be an individualized determination. I mean, so in your X and Y example, it may be that you don't make it because they don't, right?
There are the mandatory restrictions, A, that Justice Cordy is referring to, falls into that category. And then there are the discretionary, and the purpose of the discretionary is for that individualized assessment.
Yeah, the individualized assessment is that you have not been determined to be eligible for parole. That's an individualized assessment for you. Now, a couple of your clients actually been denied parole.
That is correct.
So, okay, so that would that also be something that one could take into account, the fact that you've been denied parole? So therefore, you shouldn't be going to minimum?
Well, the way the DOC looks at it is that, yes, the parole determination is in fact the screening mechanism for minimum security, although there's nothing in any of our statutes that actually set up that diagram. But the fact that they've been denied parole, maybe you look at the reasons that the parole board.
Not ready, not participated in the prison programs. That's what most of these folks are probably.
And that may be an individualized determination that makes sense. That in fact, in the medium security facility where you are, there's this program, this program, this program that you would benefit from and you have not yet participated in. That would basically, if you look at the wording of their own regulations, they specifically state that a rationale must be provided, but that these discretionary.
Denied parole, it wouldn't be enough. You've just been denied parole, so we're not going to put you in minimum security.
You're denied parole, but the setback, for example, in Golston's case is in 2017, he'll be eligible again. If you look at the meaningful opportunity for release based on demonstrated maturity and rehabilitation, that in fact we've said under Article 26 is what this is about for a lot of these individuals.
You're getting a constitutional right now to minimum security?
I'm not saying there's a constitutional right. I'm saying there's to minimum security. I'm saying that part of the role of minimum security is to help prepare the individual for release to the street.
An individual who is going to be released because they have either their date for release is coming up or they have been deemed eligible for parole.
Let me point out that in the DOC's own survey of 25 states, 23 of the 25 states actually send people to minimum prior to a positive parole vote because.
So what?
I'm just saying that it is part and parcel of the reasoning, and it goes
We
to,
know what the boundaries of those minimum securities facilities are, whether they have a perimeter fence, do we know anything about the specific security measures in those states?
no, I
Or
certainly
the
don't.
escape patterns or anything like that?
I certainly don't. But what I do know is what the legislature specifically stated in and when they amended Chapter 11972B, and they basically said that there is a remedial and protective intent when the offender was a juvenile at the time of the crime, and that we have to make special provisions for them. And that's what this was designed to do, and the Commonwealth, the department, in its own thinking about this, has developed its own policy and is basically imposing a categorical
Do you
bar.
make an argument that there is an inappropriate delegation of authority to the parole board? In the sense of to make the determination whether minimum or not, since that seems to be the criterion that the department is using?
We haven't made that argument here. That's probably a case for another day. But the fact is that what we have now is a situation, and let me take it an even step further. Let's say that the parole board said, okay, you have to go to minimum. And under DOC's discretion of, we don't have a categorical bar. What if they decide, okay, we're not sending that person to minimum? Then we have two executive agencies. We have a procedural due process issue, and that's sort of taking it to its furthest extreme.
Well, if you're paroled, if you've got a favorable parole decision, the parole board has made a determination that the public safety would be adequately secured by your release, right? So there's been a fairly significant determination, and you're suggesting that somehow the Department of Corrections would say, well, that's what you think, but we're not going to allow this person to go to minimum in preparation?
They've basically said to the legislature, that's what you think, but, we're not doing it. So I'm just carrying it to its hypothetical conclusion.
All right, thank you. Mr. Anderson, good morning.
Good morning. Charles Anderson. I represent the Commissioner of Correction, Thomas Turco, and the Assistant Deputy Commissioner for Reentry for the Department, Carol Michi. The department classifies juvenile lifers so as to promote their phased reentry into our communities, not for their comfort or preference.
Does it mean at a minimum that no one can be paroled within the parole eligibility period? If you're parole eligible in 15 years, under the policy that your department is implementing, somebody could not get out in 15 years?
They would be eligible for parole in 15 years. The parole board, as part of their
But as a
determination.
practical matter, they could not be released in 15 years.
That's
in the
correct.
15th year.
Yes, they
It
would
would
be
mean at
able-
least 16 years in ordinarily.
Depending upon what the conditions the parole board set for as part of parole release. The entitlement in the statute is that they see the parole board in 15 years, not that they get released in 15 years. And as this court said in Dachenko 1, that Article 26 does not, or the case cannot be construed so as that petitioners should be, or juvenile lifers should be released after serving a statutorily designated portion of their sentence.
Wait, when you say, what is the precise language of the statute? It says they shall be eligible for parole,
Yes,
15 years.
yes.
But isn't it fair to say that the legislature understood eligible for parole meaning eligible to be paroled to the street?
Correct.
But they're not. Under your provision, as a result of DOC, they're not truly eligible for parole to the street for another year because they would have to then go to minimum security, and it would delay generally for about a year their release.
This is not a DOC provision, Your Honor, in that the practice, as long as I've known going back, has been when the parole board determines that a lifer, one serving a life sentence, is suitable to be released on parole, the parole board puts as part of their conditions of parole release that they're going to be transitioned down to the street through minimum security.
Right.
So this is,
So this is a longstanding policy which one would expect the legislature would have recognized.
yes.
And so why should we not understand this provision to say we are now determining when the minimum period for eligibility is, and we know that There will be minimum security that will be required before one gets released to the street. So we're going to speak in the statute that addresses the eligibility for parole date to an issue which we know is connected to that, which is when you are eligible for minimum security, and we're going to limit the discretion of DOC with regard to that to the discretion which it has already established by its own objective measures.
Well, the legislature could have done that, but it didn't do it with this change to the amended statute.
Why is that? I mean, they speak about objective measures determined by the department. So DOC, they're not taking away the ability of DOC to determine objective, and I assume by objective, one would understand objective to mean based on objective empirical evidence. Is that fair to say?
That is fair to say, but the objective evidence that we're referring to may not just be limited to the point-based score, which is determined objectively, but also to the restrictions and overrides that are determined objectively, such as somebody being within 5 years of their earliest release date, such as somebody not having received a positive parole vote and their crime involves loss of life. The legislature could have restricted in the amended statute the department's discretion to classify an inmate based upon their proximity to their release date, but it didn't. It's simply said that they cannot be categorically barred based upon a life sentence.
Right, but DOC has, through exception A, whatever it's called, has essentially said it matters a great deal whether someone is going to be able to see their release date. And so we're not going to send anybody to minimum security if that is, if the vision of that ultimate release date is at least 5 years away. They've made that determination, that 5 years is the distance by which somebody should not be. Why is that? Why should that not apply here? Why should there be essentially a categorical bar which says for everybody else you must be within 5 years of your release date, but for this category of juvenile offenders you must be already paroled?
Because that's not the only that's not the only restriction that impacts the classification. In that category, the way that the process works is once the point-based score system is developed, the classification board goes down the list of restrictions. And if any of those restrictions apply, then objectively the person cannot be classified to minimum security.
Right, and you have one which says, regardless of what the score is, if they're more than 5 years away from their parole eligibility date, they won't go to minimum security.
Yes, that's one of, and just as another code is.
So, but now, essentially, what you're doing, what the DOC is doing is saying for everybody else, 5 years is the determinant. But for this subcategory of offenders, even though they may be within 5 years of the parole eligibility date, they will still be automatically barred until they actually have been paroled. That's what's going on, isn't it?
Well, it is that the department is looking at what is their release date and determining what is their suitable classification. And while the department hasn't, the criteria is not based on a life sentence, but it's based on what's the established
It
release
is a
date.
categorical, it's just the same as A. It's a categorical bar for this particular cohort.
It is not a categorical bar in that the way the process works is going through the different categories and the exclusions. That is done based upon not an individualized assessment, or it's looked at what is their date for parole eligibility. Does their crime involve loss of life?
But I mean, if you've got if you're not within 5 years of your parole eligibility date, that's a categorical bar, right?
Correct.
Override.
Yes.
Categorical override.
Code A.
So
Code
I
A.
think-
It's a mandatory restriction.
Yes. So I think the question that we're posing is, why isn't this one, that is, if you are a juvenile who's been convicted of first or second degree murder, there is a categorical override that you will not be eligible for minimum until you get a positive parole vote.
That is the practice of the Department of Correction, and it's not just with respect to juvenile lifers, it's also with respect to those who have crimes that involve loss of life or committed a crime while they're incarcerated or murder of a public official.
Well, what about somebody who was convicted of armed robbery and received a sentence of 60 to 90 years, 60 to 90 years? How does this affect them?
How this would affect them is until they get to the point, well,
Same thing.
category, Code A would exclude them until they get to year 55 in their sentence. They're 5 years away from their parole eligibility at that point, so they'd be eligible under Code A to be placed a minimum. But the question then remains, do any of the other mandatory restrictions apply, and do any of the other discretionary restrictions apply?
Now, in these circumstances, in minimum security, is there a period of time beyond which people are not put into minimum security? I mean, how long do they spend in minimum security? Is there a protocol as to how much time a person should not spend in minimum security? I mean, they try to get people in and out. Is it a phase that's close to release, or can you spend 10 years in minimum security?
You cannot spend 10 years in minimum security. That's because of Code A. But the way the department handles this is minimum security is used for those who are discharging to the street in a matter of months, not years. The average that's contained in the Michi affidavit is that for those released from minimum or pre-release custody, the average for those serving a term of year sentence being housed at that security level is 16 months. Those serving a life sentence housed at that security level and released is 12 months.
Are there any policies or considerations that keep people who are within 2 years of release away from people who are more than 5 years from release?
There isn't a policy per se, but the way the interplay works between our different classification codes, that comes into effect. For example, looking at Code F, not only is there a restriction for not having a positive parole vote, but also the other restriction is or being within 2 years of a defined release date. So those whose crimes involve loss of life, murder of a public official, or if it's a crime while incarcerated, they are not going to be considered for minimum security unless they've seen the board and received a positive parole vote or within 2 years of their discharge. So
Is seeing the parole board and the positive vote, is that actually written into a category, or that's just your policy?
That's F. Well,
it is Code F.
but Code F, how does Code F now apply to juveniles?
Code F doesn't specifically apply to juveniles because they've been excluded by the rewrite of the code, but the department did that for the purposes so that we're not just barring somebody based upon the simple fact that their crime involved loss of life. What we wanted to do in changing Code F is to make sure that the boards, classification boards, as well as the Assistant Deputy Commissioner of Classification, went through each and every one of these restrictions and overrides to see what was applicable. Before, you only got as far as Code F, and it was over. At that point, you know, once this was rewritten and it was in accordance with the protections afforded to juvenile lifers, is that we wanted to start classifying them on a case-by-case basis, not just.
Why? So if you're supposed, if you want to classify them on a case-by-case basis, it sounds to me that the discretionary overrides, or whatever they're called, the discretionary categories or discretionary what are they
Codes.
called?
They're called discretionary overrides. The mandatory
Discretionary
ones are
overrides
restricted.
should be based on an individualized determination rather than, well, the only factor being, have you received a parole, have you been qualified for parole? Have you received a positive parole vote?
Well,
Is that the only individualized criteria that's used?
no, the individual criteria is that the Assistant Deputy Commissioner will go through all of the various overrides and determine which one is applicable. And in this case.
Which one is applicable
Bingo.
here, to the two of the three? I know one of them has a couple
Yes,
of
to each of
over-
the petitioners. I think 2 out of 3 of the petitioners have had parole that's been denied, but I
Right.
believe as against each of the petitioners, Code R had been applied, and I believe also
And Code R is?
Code S as to one of them.
that Code S says to Mr. Roberio, I believe,
Right,
as
but
well.
Code R is, remind me?
Code R is the nature of the offense or the notoriety of the offense. Code S is the
So
prior
murder,
criminal
so this
history.
is murder. So Code R is murder. Why isn't that categorical then?
It isn't because it's not considered just as murder on its own. If you go through the restrictions First, you look at Code E, whether there's a life sentence or not, or non-parolable life sentence. That's not the case here. Code F, whether crime involves loss of life, that category no longer applies here, but this is how it works down through it. You get down after that, after passing Code E and Code F, which don't apply anymore, you start looking at the particular facts and circumstances of the crime, not just merely whether it involved loss of life. And what you have with regard to these petitioners is, even though the basis isn't required to be stated on the classification report, there's been no allegations of support for that. The nature of the offense of these petitioners is one that should not exclude them from minimum security.
Wait. Page 153. Ms. Michi, in the end, it is department practice that only inmates who have a specified date of release to the street can be housed in minimum security or below. True?
Yes.
So there is essentially a categorical bar to any inmate who is a juvenile life offender who has not been granted a specified date of release, either by parole or by the end, well, there is no end to their sentence, by parole.
We don't consider it a categorical bar.
I know you don't call it a categorical bar, but it's invariable. Is there any exception to it?
To date, there have not been any exceptions to it. But when you look at the language of the statute, it talks in terms of categorical bar based on a life sentence. This is not a bar based on a life sentence. It's based upon whether or not there's been a positive parole vote.
But it applies only to those who have a life sentence.
Who are juveniles?
Who are juveniles.
It applies, I would say it applies to anybody who has a parolable life sentence.
Well, let's go to Justice Spina's example, the 60 to 90. After 55 years, they could be going to minimum security.
Based on Code A, but I believe the example was for armed robbery.
Okay, so let's
Code F
use
wouldn't
that.
apply.
So armed robbery, so 55 years, they could go to minimum security, and they could be turned down for parole at 60 years.
But Code F would keep them out of that. Code F.
It depends on what the facts and circumstances of the crime were. I believe what the hypothetical was an armed robbery, so Code F wouldn't apply there.
They could remain in minimum security unless after the parole denial they say, we think that you're too upset about that and you may be escaping, we're going to move you to medium, but you could stay in minimum security after that.
I mean, that's under classification Code A, but I do believe somebody who has that amount of time to their discharge date is not going to be housed in minimum security.
Okay, let me ask you this. Could the commissioner, in your view, establish Code Z? Code Z, which says only inmates who have a specified date of release to the street can be housed in minimum security or below.
Yes,
So you say they could do that, and
Yes.
that would not be a bar,
that's correct.
because that's exactly what you're doing now. Well, that's what Ms. Michi says you're doing now.
That's correct. That is the practice of what is being done.
And you
yes.
say that would not violate the statute? That would not be a categorical bar?
No, it is not, because it is based upon whether or not they have a specified date of release, not whether the fact that there's a life sentence. If the facts were a little bit different, instead of somebody was serving 15 to life, they were serving a 15 to 20, the same principle would apply. If they were serving a 15 to 17, Code F wouldn't apply, because the other exception on that is they'd be within 2 years of a specified release date. So it really comes down to whether or not somebody has a specified release date and when it is. Just by virtue of the fact that they're serving a life sentence, they do not have a specified date of release until they're found suitable by the parole board.
So you're saying, in the words of the statute, if a youthful offender qualifies for placement in a minimum security, the word qualifies is something that the commissioner can determine?
Yes. 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 And it does say based on objective measures as determined by the department, which I read as not only being the objective point-based scoring system, but also the objective measures that are contained in these restrictions and overrides.
And there is no override right now.
I'm sorry?
There is no override right now.
There is no override right now for specifically what we're talking about.
Right. It's just been established by practice.
Yes.
Okay, thank you.